All right, good morning, everyone. This is session 6 of the Housing Information Series, and today we are talking with Andrew Sherman. And Andrew, can you tell us a little bit about yourself?
I'm a solicitor licensed to practice law in the province of Ontario. I work at Davison Tuckey Law here in Trenton, and my primary areas of practice are real estate, firstly, which is why I'm here, but I also practice wills, estates, and corporate law as well.
Okay, that's great. So we are going to dive right in today, and we're going to start talking about both purchases and sales. So go ahead, the floor is yours.
Excellent. So I know the broader context of this conversation is that buying and selling homes, especially in today's market, can be quite stressful. There's also a lack of availability in housing. And I've given a lot of thought to that broader context, and I came to the conclusion that there's not really much anyone individual or professional can do to change that broader context. But what we can do is make the process of buying and selling homes a bit less stressful. And two main things that I believe help with that, and in my experience purchasing and selling homes or acting on the purchases and sales for individuals, is openness and communication and availability. In the context of military service members buying and selling homes, the very first thing you're going to want to do is make sure your lawyer actually receives your agreement of purchase and sale from your real estate agent.
Okay.
That puts the lawyer on notice that there is, in fact, going to be a transaction closing on a certain date. Obviously, a very good starting point. Another very important key point for military service members to keep in mind is you're going to want to have your BGRS number on hand when you first contact your lawyer.
Okay.
Because your lawyer is going to be submitting for their fees and disbursements through BGRS. The earlier they're able to do that, the more likely it will be that those funds will be available on closing.
Right.
With respect to availability, you're going to want to consider where you're going to be when the purchase and sale takes place. And in that regard, it's important to keep in mind that a lawyer can only deal with real estate in the jurisdiction in which they're licensed to practice. So, for example, if you're selling in Alberta and purchasing in Ontario, you're going to need a lawyer license to act on the Alberta portion of the transaction and the Ontario portion. A lot of people don't consider that. And looping back to communication too, is you're going to want to make sure that those lawyers know who the other is and what their contact information is.
Okay.
So if you're selling in Alberta and you're purchasing in Ontario, your funds have to get from the Alberta lawyer's law office to the Ontario lawyer's law office. If the lawyers don't know their trust account information or who to call in order to access or transfer those funds, you're going to have a problem.
Okay.
And
so
that's
really important for them to be in communication.
Certainly. Okay. Yes. And oftentimes we'll find that people haven't given that much thought, and that's perfectly all right. But if you can kind of think ahead when you're at the agreement stage of the transaction, maybe think who you're going to hire to act on your purchase and your sale, it's a lot easier to give that information when you reach out to your solicitors.
Okay.
Another thing with respect to availability is you want to make sure you know where you're going to be on the closing date. Most lawyers are set up to be able to sign transaction documents with their clients remotely, but that's something you're going to want to let your lawyer know of well in advance. Say you're going to be out of province or deployed, because there's different documentation that needs to be satisfied. And if you're buying, sometimes your lender may not be in agreement with remote signups because of the increased likelihood of potential fraud.
Okay.
So you're going to want to let the lawyer know that you're going to be able to either attend at their office to sign, or whether you're going to need to sign remotely.
Okay.
In that regard, too, we've found that military service members can often make use of powers of attorney for property. And what those documents do is they authorize an individual to sort of step in your shoes and act on your behalf with respect to your property for things such as signing an agreement of purchase and sale and signing a deed to facilitate a transfer. So if you are absolutely going to be unreachable, maybe appoint a significant other or some other family member that you trust to make those decisions and sign those documents for you while you're away. That covers the broad strokes, I believe, with respect to purchases and sales.
Okay, perfect. Sounds good. So why don't we move on to specifically talking about sales?
Alrighty, so this is where sort of the exchange of information between client and lawyer, solicitor is very important. You're going to want to have your most recent mortgage statement on hand if you're selling.
Okay.
And that's because a condition of almost all sales is that you need to pay out your mortgage on closing.
Okay.
So by giving your lawyer either your mortgage statement or even your mortgage reference number, they're able to communicate with your existing lender,
Okay.
put the lender on notice that a discharge is in place. And for military service members, this is important because the discharge statement is going to, and that's the document that sort of initiates the removal of the mortgage from your land.
Okay.
It's going to have certain fees on it, like discharge fees, registration fees, and those are all fees that you can recover from BGRS.
Right.
So the sooner you give your lawyer the information with respect to your current mortgage, the sooner your mortgage can get a statement from the lender setting out those fees, and in turn, try and recover those fees from BGRS.
Okay.
And in that regard as well, you're going to want a copy of your most recent property tax bill.
Right.
And that's just because when you're closing a transaction, your lawyer has to prepare what's called a statement of adjustments, and that takes your agreed upon sale price and adjusts it by certain things. And almost always property taxes is one of those adjustments. The vendor pays from January 1st of the current year to the day before the closing day.
Mm-hmm.
And then the purchaser is going to be responsible for paying taxes from the day of closing until December 31st of that year. So the sooner you have that tax bill in your lawyer's hands, the sooner they can make that calculation for you.
Yeah.
Another thing that vendors want to keep in mind is if when they bought, they were given a survey of their property. Very important to give that to the lawyer that's acting on the sale portion. The lawyer can look at it and see if there's any encroachments or potential boundary issues that may delay closing.
Okay.
Because the last thing you want is for those kinds of discussions to arise on the day before closing or a few days before a closing. So it allows your lawyer to anticipate issues. Likely they'll reach out to the lawyer acting for the purchaser. There will be discussions, and it allows each side to reach a solution before it becomes very stressful when it's actually time to sell. Exactly. So if you have a survey, give it to the lawyer acting on your sale. It's very important that they review that.
Yeah.
Another thing is most people are under the impression that lawyers will reach out to utility service providers for you. The reality is, for privacy reasons, mostly most utility service providers will only communicate with the owner of the home. You're going to want to let your utility service provider, so again, this is water, gas, internet, hydro, you're going to want to let them know that you're moving out on a particular day.
Okay.
Because they're going to in turn want to reach out to the new owner who should be receiving bills for those services moving forward.
Yep. That makes sense.
So you should make those calls yourself. If you rent a furnace or hot water tank, oftentimes those are rental items. So that's another point to keep in mind, is you're going to want to say it's Reliance Home Comfort or one of those businesses.
Yeah.
You're going to want to let them know that you're moving out, because the purchaser will want to assume that rental contract. And oftentimes the rental service provider will give you documentation that needs to be filled out. But oftentimes over the phone, you can simply give them the name of the purchaser and their address for service and other contact information, and they'll know to reach out to the new owner of the home, just to once again ensure that you don't keep receiving bills for those rental items.
Yeah, we don't want that.
No.
Make a smooth transition.
Exactly. And I've had people not take that step, and then a year or two down the road, they come back to me and say, I've been continuing to pay for this hot water tank for the buyer. What can we do about that? And the reality is, had the client acted a bit more diligently and made those calls when they were instructed to, this all could have been avoided. Now, if that does happen, usually there are undertakings that are signed by both sides to ensure that each side pays the proper fees that they should be paying. So we can usually rely on those to fix it after the fact, but generally speaking, easier to fix them closer to closing than a year or two down the road.
Exactly.
If your property is heated by oil or propane, it's customary, at least in this area, when you're selling, to top it up for the purchaser. And that's just an act of good faith, especially in the winter. We want to ensure that the home remains heated.
Yeah.
We don't want any pipes to freeze or any damage to occur.
Right.
And the final point, and this is often a point of misunderstanding If you own property in Ontario with your spouse, regardless of whether or not your married spouse is on title, that spouse is going to have to sign your transaction documents. So oftentimes I'll have people approach me and say, well, my husband or wife isn't on title. Do they need to attend at the office to sign? And the answer is, if you're married, yes. If you're a common law, that's not the case. But the fact of the matter is, in Ontario, married spouses have, I guess you could say, automatic rights with respect to each other's real estate. So regardless of whether your spouse is named in the purchase agreement or registered on title, they're going to have to come in and sign documents indicating that they consent to the sale of the matrimonial home. That pretty much wraps it up with respect to a lot of the points of tension that we encounter with respect to sharing information, insofar as it relates to sales.
That's great. And when you say on title, specifically, you mean like when the spouse is, when both of their names are on the agreement?
When on title, I mean, when you acquired the house, there was a deed that was registered. Both spouses would be on title if both of them are named on that deed as the new owners of the property. Oftentimes what will happen is, say one of the spouses has bought a home before they married. There wouldn't have been an opportunity because that other spouse wouldn't have really existed or been known at the time. So they wouldn't be a registered owner. So if you were to look in the land registry office, it would just look as if one of the spouses owned the property. But the reality is, when you marry, it's as if that spouse is an owner on title. There's just no documentation to reflect that. So if you marry and it's a matrimonial home, regardless of who appears in the land registry office as the owner of the property, both of you are going to have to sign transaction documents. So I guess the main reason why I brought that up is sometimes when you're moving, one spouse will stay behind with the family and the other will come here to help close the purchase or sale. You'll want to make sure that both spouses are available, either in person or remotely, as we discussed, to sign those documents. So just don't go, if you're married, don't go into a transaction thinking that only one of you can sign the documents.
Thanks for clarifying.
Oh, no problem.
So, and then we'll move on to purchases.
So again, in real estate, and I'm sure you'll discuss this with your real estate agent, but a lot of the responsibilities with respect to due diligence, researching title, and making sure that the property is as you want it, that rests with the buyer. Buyer beware, very common principle. But the main thing, again, coming back to the proper exchange of information between client and lawyer. If you're buying a home, you want to tell your lawyer whether or not you're also selling in order to buy. You want to make sure those dates line up and the timelines line up, because the sale proceeds are often used to complete the purchase. You don't want the order of transactions to be arranged whereby you're buying and then selling. Of course, that is something you can do with bridge financing, but we can discuss that perhaps later. And again, with respect to financing, firstly, you're going to want to make sure that your lawyer knows that you're borrowing money. And if so, which institution are you borrowing it from? Because that lender is going to have to reach out to your lawyer, and they'll often have a list of conditions that need to be fulfilled. And your lawyer is going to want to have that list of conditions well in advance. You don't want to be in a position where 2 or 3 days before closing, everyone's scrambling to satisfy the lender that you are in a position to actually take good title to the property. So again, just when you're making your initial call to the lawyer acting on your purchase, let them know whether you're selling your home and whether or not you're borrowing money from an institution or some other lender. And let them know the identity of that lender. So again, the lawyer can make contact with the lender and requisition instructions and satisfy conditions well in advance of closing. If you're buying a new home, again, and I alluded to this before you're able to sell your current home, you can facilitate this by oftentimes securing bridge financing, and your bank advisor or mortgage broker would be perhaps in a better position than me to discuss the intricacies of that. But for our purposes, the nice thing about bridge financing is they will advance funds to close your purchase. And then when you sell your home at a later date, the sale proceeds will be used to pay down that bridge financing and pay it out.
Okay,
So you're essentially telling the lender, I will be selling my home in the future. If you can simply
Yeah.
advance the funds to purchase now, I'll be able to pay you back at a later date.
okay,
Again, important because your lawyer will be receiving those bridge financing funds.
yeah,
It's important to let your lawyer know whether you've arranged bridge financing or not. Because lawyers at the 11th hour don't want to look at your all the financials of your purchase and say we're short about $200,000 or $300,000 here. Where is it coming from? And then you tell them, oh well, I forgot to tell you I'm getting bridge financing.
yeah,
So again, just let your lawyer know what your plans with respect to financing are.
okay,
If you're unsure, you can communicate that appropriately to your lawyer. You can always put your lawyer in touch with either your mortgage broker or your bank advisor.
okay,
Again, if you're a first-time home buyer, you should let your lawyer know as well. And generally speaking, what that means, just to keep things simple, is neither you nor your spouse have owned a home at any time anywhere else in the world.
okay,
So it's not just the case that you have never purchased a home. You
Yeah.
have to ask yourself whether your spouse has as well.
okay,
Nice to let your lawyer know that in advance, because the rebate isn't money you receive after the fact. It's actually knocked off from the funds you have to bring into your lawyer immediately. So if
Yeah.
you believe you're a first-time home buyer, let your lawyer know and they can discuss the criteria with you,
okay,
come to a final determination, and that'll allow you to save a bit of money
yeah,
off the top. It'll be a nice bit of savings in your land transfer tax figure.
okay,
And again, if you're purchasing a property with an individual who is not a spouse or a trusted relative,
yeah,
you also may want to discuss the possibility of a co-ownership agreement with that other individual. And all that is it's a written document that usually gets arranged before closing and signed on closing, setting out the rights and responsibilities of each of the co-owners.
right,
If you buy a property with an individual that you feel you may have conflict with in the future, whether it's a conflict of interest or just uncertainty as to who's paying for what, utilities, maintenance, the
Yeah.
like. It's often helpful to put all of that in writing going into it. And usually one or two lawyers will assist in that. But again, it's nice to have some certainty when you're buying and sharing property with another person. We don't often have such agreements in place because usually it's just spouses acquiring property together. But certainly if you're buying property as an investment or just to share space with someone that you may not know as well as you think you should,
right,
it's nice to set those rights and obligations.
yeah, that
in
makes
writing.
sense.
And again, if you're going to purchase the property and you're acquiring a mortgage to do so, you're going to usually want to make sure that you're actually going to reside in that property. If you intend to use it as an investment property, you're going to want to let your lender know right from the beginning,
Yeah,
because there's different mortgages that fulfill those purposes. There's mortgages for building, there's mortgages for investment properties, and there's mortgages for properties that you're going to reside in. So mortgages
Okay.
for standard purchases. You don't want to be in a position where you've arranged a mortgage through your bank advisor and it's just a standard purchase mortgage, where you really intend it to be income producing property at a later date.
okay,
So you really want to be transparent with your lender at the beginning. And the reason why I say this is if you have to change your mortgage instructions, and once again, we're quickly approaching the closing date, that can delay closing and cause a lot of unnecessary stress.
okay, good.
So it does, when you're planning to borrow money, whether it be with the help of a broker or your bank advisor, just be transparent as to what your intended use of the property is.
Okay,
Because oftentimes when the lawyer receives those mortgage instructions, it's too late to change them
okay,
without delaying the closing date.
okay,
Another important point to keep in mind, and especially when military service members are buying property, is you're going to want to look at the acreage. How
Yeah.
large is the property you're buying? BGRS places restrictions with respect to compensation or reimbursement of expenses if you're buying over a 1.25 acre limit. And usually, I'm just saying this now, and I trust if you speak with your real estate agent, they would advise you the same thing.
okay,
But you don't want to be in a position where your property is above that 1.25 acre limit and BGRS limits funding that you were otherwise counting on.
right,
Now, there are ways to mitigate this if you buy a property that's over that limit. Usually we do this by submitting evidence to BGRS that the amount of the property, and again, speaking with respect to its size, that's over that 1.25 acre limit, wouldn't have substantially changed the value of the property.
Okay.
Another way we can deal with it to guarantee that you receive the maximum amount of BGRS benefits that you're entitled to is getting a letter from the municipality if the municipality requires lots to be greater than that limit.
Right.
Again, though, those two avenues to sort of circumvent that limit aren't always available. So you'll want to carefully discuss that with your real estate agent going into a transaction.
Okay, good to know.
Another thing we're seeing now is if you're purchasing a property, and this is particularly the case in this area, we still have a lot of rural homes that are serviced by wells.
Yep.
You're going to want to get a water potability test,
right,
regardless of whether your agent has stipulated that that test needs to be taken in the agreement or not. Because most lenders are now withholding funding if they don't have water testing in place.
Okay.
You can imagine a situation where someone moves in, the water is not of a drinkable or potable quality.
Yep.
That causes a lot of issues, and you've now put a mortgage on a property that has a water problem.
Yeah.
The lenders aren't going to like that. So really nice to test the water going into closing, and then if the lender has any concerns, we can address them at that time before you fully committed to borrowing the money from them.
Okay.
Or registered a mortgage on title. Because usually there are courses of action you can take to purify the water, but you'll want to do that before closing.
Yeah.
I know that was quite quick on a lot of information, but
no, that was really helpful. Does that have, in terms of the water potability, it just made me think of properties with septics.
Yeah, so septic is something we can oftentimes title insure over.
Okay.
But I think in most cases, your real estate agent would recommend at minimum a representation and warranty that the septic system is in working order and that the current owners haven't had any issues with it during the course of their ownership.
Okay.
But oftentimes too, I would strongly recommend getting an inspection before you firm up your offer. That oftentimes, depending on the vendor's position, isn't always something that can be achieved. So there are ways to insure over that risk, but in almost every case, I would recommend testing and inspection of the septic system.
Okay.
But again, that's from a practical perspective, that's not always possible.
Right.
But that's something you will want to discuss with your agent before you firm up any agreement of purchase.
Definitely.
So,
yeah. And those are probably things that if you're selling a property, especially here, because we have so many rural properties, you might want to do that in advance, not just when you're purchasing a rural property.
exactly.
If you're selling one too, that would be a good way to prepare for whoever is purchasing it.
No, that's a very good point, because oftentimes you're selling in order to purchase. If your septic's not in order and the purchaser is unable to secure funds or are simply unwilling to close the purchase because of the septic system, all of a sudden now you're short those sale proceeds to facilitate your purchase. You get lost in that chain of transactions and both transactions fall through.
Yeah.
But usually most good real estate agents will at minimum have a representation and warranty in the agreement saying that the septic system is working.
Okay.
And most lenders I've worked with will accept title insurance so to cover the additional risk of a septic system. But increasingly, again, we're seeing that lenders aren't allowing you to title insure over water testing, water potability. So, and the fact of the matter is too, a water potability test is not necessarily an expensive thing to do. It can be turned around in 3 or 4 days most of the time.
Take long.
But then moving in that the water is safe, and more importantly, that your lender is going to be happy and actually advance you funds on closing. Do you have any other questions for me?
I did just have a question and now I can't remember what it was. Oh, I wanted to ask you, okay, when people are coming on their house hunting trip, typically, they're reaching out to realtors in advance to get properties available to view. Is that also a good time to connect with a real estate lawyer as well in preparation for your house hunting trip? Or is that something that you don't want to wait until the last second when you come on your house hunting trip to arrange?
No, we see that all too often, especially if you're not familiar with the area. Most of the time, people will not pick their lawyer until, I shouldn't say most of the time, but oftentimes we'll encounter situations where they haven't given much thought as to who their lawyer will be.
Right.
Lawyer gets an agreement faxed to them a week before closing, and you can see how that would cause a lot of stress.
Right.
So you should, perhaps when you're retaining or hiring an agent to represent you, give some thought as to who your lawyer will be.
Okay.
And although we don't often see this, it may also be wise in certain circumstances to have a condition in your agreement saying that your lawyer is to review the agreement before it becomes firm or is fully executed.
Okay.
That sort of forces you to put yourself in touch with the lawyer, and it also allows your lawyer to give you some feedback as to the contents of the agreement
Right.
before you're fully committed to it, as it were. But you're exactly right. It's very good to select who your lawyer is early on in the process.
Right.
Reach out to them, and as I've mentioned, exchange all of this information we've discussed here today and discuss what your availability is. The sooner you deal with those things, the better. These real estate transactions may seem easy on their face, but there are a lot of stars that need to align to make them all work.
Yeah.
The sooner we can get a look at what those stars are, we can start shifting them into place and make sure everything works.
Right. Okay, that's really great. Well, thank you so much. I appreciate your time.
Oh, my pleasure.
Provided us with a lot of really great information. And if anybody has any further questions or concerns, just reach out to me and I can get you connected with the right answers. Thank you for joining. Have a great day, everyone.